You're the smartest of all audiences. Why? Because we get into things that others are not going to get into, and other networks and so forth. And I don't do the fan dancing and everything else to grab your attention. Substance, intelligence. That's what I do here. And we're going to need that today, right now. I want to explain something to you. Not enough attention is given to what happens in this Manhattan case and the options for Donald Trump and the American people since that case's decision. I'm very frustrated with lawyers who come on TV or radio or write articles saying that basically Donald Trump is stuck in the New York judicial gulag. He is not. I'm very troubled by lawyers who don't do their research, who don't look at the precedent that's in front of us for the opportunities for President Trump and his lawyers to try and get out of what is the New York judicial gulag. There are certain writs that we talked about before that the Supreme Court can issue, but it has to be asked. If it's not asked, it's not going to do a damn thing because it doesn't have original jurisdiction. We don't have a court system like they have in Israel and other places that can see something and say, you know, we're going to get involved in that. That's not the way it works, and we don't want it to work that way. We don't want a super legislature. The court system in this country is bad enough, quite frankly. So what do? So I want to walk through this slowly so even the lawyers on MSNBC and CNN can understand, although I don't think they give a damn, but we do, the American people. You have in this case, apart from all the local issues and all the rest, issues involving federal election law, issues involving the presidential election, the highest federal official in the nation being chosen. You have federal constitutional issues, First Amendment, free speech. The gag order, yes, but even more than that, the idea that a non-disclosure agreement violates campaign laws is not only false on the law, but that would violate the First Amendment. The Fifth Amendment, due process and equal protection rights, also conveyed on the states by the 14th Amendment, as they were ratified, that amendment after the Civil War, and the Sixth Amendment. You have a right to competent counsel, but counsel can't be competent when they're endlessly being interrupted, sabotaged, can't call proper witnesses, don't have notice of what laws are involved, and so forth and so on. Then you have facts that suggest, well, this isn't a mistake, the timing of the case. After the federal authorities rejected it and local authorities rejected it, this case was brought for the purpose of interfering in a federal election, federal campaign, and usurping federal authority. And it was timed in order to create this very convoluted, slow appellate process within the state. So major issues could not be resolved, even if that was the proper line of appellate courts before the election. So this is a ongoing violation. Now the question is whether Donald Trump will have to wear an ankle brace, whether he'll have to get permission from a probation officer every time he travels to a state, whether sentencing will be stayed, and on and on. So we're all waiting around for politically Democrat judges to make decisions that belong in the federal government. This is fundamental. And it's not just one instance. These are multiple federal constitutional and legal issues that cannot be resolved by the state of New York, that must be resolved at the federal level. Must be resolved at the federal level. The issues are compelling. They're overwhelming. For this election and future elections, for this republic, how we elect presidents, and for our electoral system. If there's ever been a case that the Supreme Court should take up, and I would argue would take up, it's this case. It checks off all the unconstitutional and unlawful activities that would trigger Supreme Court intervention. Now, I can't predict that in advance. The basic pushback I get from some of these lawyers who really don't understand what they're saying is, well, the court's not going to take it up. How do they know? The court took up Bush versus Gore. The Bush and Cheney campaign weren't waiting around for a final decision by the Florida Supreme Court. and said, well, the Supreme Court won't take up the case. They took the case to the Supreme Court. They weren't even sure how to characterize their case as an emergency appeal. The court accepted it as a writ of certiorari. Doesn't matter. On December 8th, in a 4-3 decision, the Florida Supreme Court ordered immediate manual recounts of overvotes for the office of president in all counties where such recounts had not already taken place. They were changing state election law, and they were cherry-picking counties that would help Gore. The Bush campaign petitioned the U.S. Supreme Court for a stay of the recount order, writes Britannica, which was granted on December 9th. Treating the petition as a writ of certiorari, a formal request for review, the court agreed to take up the case, Bush versus Gore. The Florida Supreme Court was out of control. They were interfering with the eventual electoral count in Florida. They were trying to deliver the race to Gore. The justices, among other things, they're flesh and blood. They're human beings. They shower like we do. They eat like we do. They do other things like we do. And they see what's taking place. They saw that this court was out of control, changing election laws to advantage Al Gore, and the Supreme Court knew it. At oral argument on December 11, Bush's legal team asserted that the Florida Supreme Court had exceeded its authority by ordering the manual recount of undervotes, while Gore's team contended that the case, having already been decided at the state level, was not a matter for consideration at the federal level. In a per curiam ruling issued the following day, the court found 7-2 that owing to inconsistencies in manual recounting methods and standards between Florida counties, the Florida court's order of a manual recount amounted to a violation of the Equal Protection Clause in the 14th Amendment. By a smaller majority, 5-4, the court also ruled that no new recount could take place because none could be finished by the safe harbor deadline, the date set by federal law by which states were required to resolve any disputes regarding the selection of presidential electors in order to guarantee that their final determination, quote, shall be conclusive and shall govern in the counting of the electoral votes as provided in the Constitution, unquote. The extent to which the court went to stop what the Florida court was doing, to stop the recounts in the middle of the recounting, to say that's enough, your deadline has been met, and that's the end of it in Florida, is far more extraordinary than anything Donald Trump and his lawyers would be asking the Supreme Court to do. Why? These are federal law, federal constitutional violations, federal jurisdictional violations by an acting state judge and a prosecutor, by two people. And it's ongoing. Sentencing and other issues have to be decided by the local judge, and then the appellate level, and then the level after that. This is an ongoing violation. It doesn't even matter what the final court has to say. Again, if I'm Donald Trump's lawyers, I go through that process, but you go to the Supreme Court of the United States. Now, how do we get to the Supreme Court of the United States? This is where people get bogged down. There are writs at common law, and it really doesn't matter which writ you follow. Here's a piece by former Attorney General Griffin Bell. He would later become Attorney General under Jimmy Carter. In the Southern Methodist University Law School Law Review, the federal appellate courts and all writs. And it discusses what these common law writs are. Now, it discusses it in the context of a specific statute, the All Writs Act, that was passed as part of the original Judiciary Act in 1789. Not to get into the weeds, we're smart, we can follow this. The peremptory common law writs are among the most potent weapons in the judicial arsenal. These common law writs are used. They're rare, but they're used more and more within the federal chain of courts. So what does he say here? Well, the basis for general judicial supervision over inferior courts, inferior federal courts, through extraordinary or peremptory writs can be found in early common law. The All Writs Act is a direct descendant of the Judiciary Act of 1789, other than the Supreme Court, which is created by the Constitution. Everything else is created by Congress. All the other courts, the number of courts, how many justices are on the Supreme Court. It granted federal courts the power to issue extraordinary writs in aid of their respective jurisdictions. And while it is clear that the All Writs Act authorizes the issuance of the traditional common law writs of mandamus and prohibitions, the phrase all writs also encompasses common law certiorari, injunctions, subpoenas. Don't worry about all that. What that really means is there's many ways of characterizing this direct appeal to the Supreme Court and relaying the facts and relaying what's taken place under the law to the court. In fact, you can use multiple requests for writs. It says choosing the correct writ to obtain the desired relief is no longer necessary in the federal courts. Different writs may be sought alternatively or cumulatively. The choice is now unimportant. The subtle distinctions among the various writs have no effect on their relative usefulness as vehicles for interlocutory review. We're not seeking interlocutory review at the federal level, but in effect we are of the state court's activities. Hello, before you finish on the state side, we have some big questions that the Supreme Court needs to answer. The jurisdictional prerequisite for application of the All Writs Act is simply that the writ be necessary, appropriate, in aid of the jurisdiction of the issuing court. The Supreme Court in Labai versus Howes-Letper Company explained the power of the courts of appeals under the Act. Quote, the question of naked power has long been settled by this court. Since the Court of Appeals could, at some stage of the proceedings, entertain appeals in these cases, it is power in proper circumstances to issue writs of mandamus reaching them. This is an expression of prospective or concurrent appellate jurisdiction. The power of the courts of appeals to issue writs is not limited to cases where an appeal has already been filed. Rather, this power of review extends to all proceedings where the actions of the trial judge at some future stage of the litigation may be reviewable. That applies to the federal chain. But as I explained here, we have violations of federal law, of federal constitutional provisions by a state court. Now, does the Supreme Court, does the federal government ever get involved in state court decisions or state law decisions or state regulatory decisions? You better believe it. There are things called express federal preemption, which is what we have here. Federal Constitution, federal due process rights, federal equal protection rights under the Constitution as applies to the states. Federal jurisdiction under the federal election law, under a federal presidential election, and I could go on and on and on. You have implied federal preemption. You have states that are obstructing federal preemption. You have all this litigation of precedential activity that's taken place before that gives the Supreme Court jurisdiction. A state cannot regulate Congress, which is what it's doing in that court when it takes over authority for determining what a federal election violation is. That's important. Or the Equal Protection Clause, or the Due Process Clause, or the First Amendment Free Speech Clause about a non-disclosure agreement. Federal courts, starting with the Supreme Court, have intervened in state actions before. Civil rights issues, death penalty issues, Bush versus Gore, a presidential election issue, where you have federal jurisdiction issues. And how have they used it? Well, the Supremacy Clause, they've used the Commerce Clause, they've used the Necessary and Proper Clause. When it comes to regulating federal elections, especially a presidential election, Congress has exclusive plenary power. And the Supreme Court has overall authority. When you have an extraordinary, radical, extreme, multitudinous case of violations of federal law, whether it's substantive, whether it's process, whether it's jurisdiction, this is the case. Me, as I said first out of the gate, I'd file common law writs. I'd file a writ of prohibition that restrains a body exercising public power from exceeding its powers or usurping jurisdiction, which it does not have. It seems like this. You could file a writ of mandamus, ordering a lower court, in this case the state courts, to stay their actions while the court considers. It might go with a writ of certiorari, arguing that there is a statutory basis for it. It doesn't matter. You've got to take it to the door of the Supreme Court. They will decide whether to take it or not. And if they don't, shame on them. Because if there was ever a basis for what we call a common law writ, it's this. And if they don't take it in the Trump case, they're going to have to take it in the future, because these dark blue states are not going to stop unless they're stopped.